We back at it again with some property law, so let's break this down. Okay, so your husband's grandfather has some land. He gave that land in his will to your husband, but he gave a life tenancy to your brother-in-law. Now, the brother-in-law has divided up the land in his will and given it to others. He maybe could do that, but probably not. A life tenancy is a grant that belongs strictly to the individual that it was granted to. Like, I give to you life tenancy. You can live here until you die. Imagine it like this. I've got a whole bunch of land and me and my brother both have houses on it, right? But I know that when we die, I want to give that land to my kids. So I put that in my will that my kids inherit the land, but that my brother gets a life tenancy, which means my brother gets to live and use the land as if it was his own for his own purposes without altering or destroying the land until he dies. Once he dies, the interest reverts back to my estate, and then my estate diminishes, uses the interest however it was supposed to be disposed of. So in that case, goes to my son. I'm not trying to get far too technical here, but strictly speaking, a life tenant doesn't have the authority to modify or alter the property when there are other interests. So if he's dividing up the property to give it to other people, unless his life tenancy specifically includes the remainder or his ability to dispossess the land as he sees fit, then the land goes back into the estate. And it doesn't sound like he has those permissions if he willed the land or deeded the land to your boyfriend or husband. I'm seeing multiple problems with this, okay? Because the guy that has the life tenancy doesn't actually have the ownership of the land. He has the use of the land. So he can't divide the land up and offer to sell it or do anything. Like, he can't permanently alter or change the land. He can't sell anything. He also has to maintain the land and keep it similar to the estate that it was before he took possession of it. That's in the weeds. But the land should belong to your husband. Like, it was willed to your husband, and your husband takes claim of the land as soon as the father-in-law leaves. That's how that should work. What you should do is get a copy of this will or this paperwork that father-in-law is, pushing around. Go see an estate attorney and ask them, hey, is this legit? And if they say no, don't worry about it, okay? Don't break up the family. Don't cause a bunch of arguments. Don't force him to change his will, because then he'll just get sneaky and find a way to get away with something, okay? Just take a copy of the will. Make sure that another lawyer looks at it and goes, yeah, nah, dog, like, you can't do that. That ain't right. That's against public policy. It's not how it works. And you're great. Wait till the guy dies. Challenge the will. Wait till the guy dies. Challenge the will. Your lawyer, your passed down, your everything like that, the whole thing will fall apart. And guess what? The guy that's trying to cause the problems, he won't be around anymore to cause more problems. Also, I am an attorney. I'm not your attorney. This is not necessarily legal advice. It's just a fun thought experiment on the internet. I'm not your lawyer.